Hello everyone, I'm Dr. Ankita Jain. We are here bringing you the topic of patents, and this video is brought to you by Aquis. We'll understand in this particular session what are patents, how it gets registered and protected, as well as what can be patentable, as well as what is not patentable, what is known as utility models, and also understanding how many ways we can actually do patent search information, and what are the nitty-gritties of drafting of patents. So when we look into understanding patents, basically it is one of the most strongest kind of intellectual property right, and it gives you as an owner or author of it exclusive right for being an inventor, creator or owner to use the invention. Now when we speak of invention, it is very different from what we laymanly use as innovation. Patents are given only to inventions. It involves creating something which is new, which can be a process or a product, that is fine, but it has to be new and inventive in nature and must have industrial application as well. It grants monopoly to the owner, where it prevents others from making, using or selling the invention without the permission of the owner, and that's how it can be worked upon as. Now what is exactly patentable? There are very few criteria to it. The first one is that an invention must be novel, means that it has not ever been disclosed in public domain, or it has ever had any existence in public domain before that patent application has been made. The second step is that the inventive step that is not at all obvious to a person skilled in the relevant or technical field, which means that the inventive step is not supposed to be a very obvious factor for a person who is already in that field. For a non-technical person or for a non-relevant person from that field, everything would look like an invention, but for all those who are relevant to it and skilled in that particular field also, it has to be an inventive step, and it has to have capability of industrial application at the same time. What does it provide once it gets registered? It gives exclusive economic rights to the owner, author or inventor of that particular patent. It also gives moral rights which remains with the inventor itself. So the credit and name attached to the invention of the inventor remains constant, irrespective of how the economic rights either gets transferred or used. Further diving deep into understanding what is invention and how is it different from innovation. Now invention is something which has first occurrence of an idea into a product or process. For example, a wheel was invented very first time only once. Today that the tires that we see or different formations of wheels that we see are going to be only advancements to the original one. Whereas when we look at innovation, anything which is newly applied to an existing idea or just adding value to a existing idea by tweaking something here and there is called an innovation. So all the different shapes of wheels or different kinds of wheels that we see today are innovations and not inventions. Now with that, we jump on to understanding what is not patentable. Now the list to that is also pretty longer, but we'll try to keep it concise here. The first factor is that something which is contrary to natural laws or public order is not patentable. Any discovery of natural substance, for example metal elements, etc., or any formulations are not patentable. Any agriculture or horticulture method of creation of these activities is not patentable. For example, drip irrigation, for that matter of fact, is not patentable. Any mathematical business methods or any mathematical equation or business methods or computer programs such as theorems, equations cannot be patentable. A mere admixture of two or more combinations such as drinking a syrup or making a juice out of a particular addition of two or more liquids is not patentable. Rearrangement of known advices, which can be for example using a product in reverse manner, is not patentable at all. So let's say for creating a product, if step 1 to 10 is specified, if those same steps are going to be specified in a reversed manner, it cannot be applicable for patentability. Then comes plants or animals or any therapeutic treatments for living creatures or physiotherapy is not patentable. There are literary, dramatics, musical and artistic works. It cannot be patented because it gets protected under the copyright law. Any form of traditional knowledge such as techniques of growing turmeric or basmati rice cannot be patentable because they are already in existence of knowledge and know-how of public since ages. Any wordmark, logo, device, slogan cannot be patented because it gets covered by trademark law. Any aesthetic appearance of a product cannot be patented because it gets covered by the industrial designs law. And any of the defense or anti-governmental factors cannot be patented equivalently. Now we come to this topic called utility models. What are utility models? It is basically a shorter duration of protection provided to an invention. The features which are unique to utility models is that the protection given to these particular models is shorter than patents, which is usually for 5 to 7 years. It gets acquired or the procedure is quicker in comparison to that of a regular patent. It also has a format of having lower fees because the application and maintenance fees are generally lower when compared to the patenting procedures. And the industry limitation is often certain to technology industry itself and specific products. Now what industries basically are applicable for utility models is electronics industry, technology related industry, mobile laptop software industry, etc. Where all do you get application procedures for utility models? It can be in countries like Japan, China, US, South Korea, and that brings us to the registration process and protection of patents. The registration for patents is a compulsory process, and for gaining protection of patents, you have to register it in every country you want or you seek protection for your patent. It can be applied individually in each of the countries, or it can be applied via patent cooperation treaty, which is also called as PCT process. Now PCT eases the application process and provides a fee discount at the application stage, and it helps the owner or inventor of that particular patent to ease out duplication of the application process and the manual methodology for application in different countries. The protection of patent is granted in a territorial manner, which means that if you seek protection, you have to apply in the respective countries, and the validity will be 20 years from the date of application. For any application, before the draft of the patent is created, there is a process of patent search, and all the patent search information that is dived deep into to search that what kind of patent it is it even novel, or to define the novelty of that patent. There are different kinds of patent search. The first one is state of art or prior art search, which means that a previous invention or product details are to be digged into the data sets that are available to understand if the patent is actually patentable or not. Second is patentability search. This is where you confirm as an inventor the newness and inventiveness of your product or the patentable technology that you're looking for. The fourth one is validity search, where you check if the technology is in the public domain or not. The fifth one is freedom to operate search, where you as an inventor ensure the non-infringement aspect of an existing patent, because if the patent has already come under public domain, it helps you as an inventor to use that technology and create advancements to that particular technology. Then comes infringement search, where you identify unauthorized use of a patent in the world of business that exists. What does a patent document really include? A patent document will have these following components. The first one being on the front page, where you have all the inventor and applicant details, including the nitty-gritties of when the application is made, when the invention is created, name of it, etc. The second part is where you explain the summary of the invention in an abstract form. Then that is followed by a written description, where explanation of the invention and prior art search is described, followed by the main part of the patent, which is claims, which is ideally the legal scope of legal protection and specifics of the invention covered by the patent, for which is also taken seriously for protection of the invention. And the last part is drawings, which is also optional, and it helps the visual as a visual support for the invention. The reason we show this patent to all of you is to make you understand that reading a patent document could sound very complicated, but it is ideally a very simplistic format. There are several patent search tools available, either on free databases or paid databases. Free databases such as USPTO, eSpaceNet, Google Patents are easily available, and it can help you understand or do the first part of the search yourself as and when needed as an inventor. The last segment is where we discuss do's and don'ts and key takeaways of patents through this session. The first do is that you have to note and store the idea with the date of organization and its origin. The second is conducting a thorough patent search. Third is applying for the correct type of patent, be it a product or a process patent. And the fourth is filing through a registered patent attorney, because as much it would add a cost to your patent application, it would also bring credibility to your application. A few don'ts are that ignoring basic patentability conditions, or not protecting or applying for it before publicly presenting the invention before the people, relying solely on personal patent search, sharing patentable information without any non-disclosure agreement, and suffering later. The final takeaways from this particular chapter is that patents are crucial for technological advancements and they offer monopoly rights. And the confidentiality of an invention details before filing is the most essential factor. Utilizing the open databases that are available for free for preliminary patent search is a must and also the most convenient factor. Integrating patent acquisition into long-term strategy of an organization can reap humongous benefits to every organization who are using it. Thank you. So one fun fact about patents is that India had recorded 25% jump in its patent application in this year, and this led to exponential growth in the patenting system of India. What is the correct age or minimum age for applying for patents? So the key fun fact here is that the youngest patent holder in the world is aged 3 years only, and the youngest patent holder from India has been aged only 9 years. This is because there is no age barrier to when the idea is created and at what stage or age the invention is created. Therefore, the terminology of how old are you is not applicable for any inventor before applying for a patent. Thank you.
Do share your feedback on where we can improve on what we just covered. Thank you.